Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about limitation periods. Cases that should have gone to the Supreme Court of Canada, but didn't. Fawzi Badawi was charged with a number of firearms offenses, and in the course of his trial, it quickly became clear that the evidence that the Crown was leading supported different charges than what he'd been charged with. At the end of his trial, after all of the evidence had been heard, the Crown applied to the court to amend the information, the document that was laid charging him, to charge him with offenses that conformed to the evidence as it was led in trial. Mr. Badawi argued that this was unfair, that the Crown had exceeded its 6-month limitation period to lay these charges, which was what the limitation period was at the time for summary offenses. He said that because these were effectively new charges by virtue of the amendments made by the Crown, that he couldn't be charged with a new offense after that 6-month limitation period was expired. The judge dismissed his application. He sought leave to appeal, and his appeal was not granted leave by the Supreme Court of Canada. But this case raises a very important issue, and one that comes up often in criminal cases. The Crown has all of the evidence and information that's going to come out at trial available to them in advance of the trial. Police officers know what they're going to come to court and say, and what information they can prove and what information they can't prove. So they're the ones who are aware well before the case proceeds to trial of what the evidence is actually going to support. They're the ones that have all the power in that regard. And shouldn't they be able to adequately articulate the charges on the information to begin with? Why should people like Mr. Badawi have to set up essentially two separate defenses in the course of a trial? One that conforms to the information and one that conforms to any potential amendments the Crown seeks to make to the information later on. This doesn't make any sense. It prejudices the accused, and allowing a Crown to amend an information to cure a minor technical defect is one thing. But allowing the Crown to amend an information to lay what is essentially an entirely new charge outside a limitation period prejudices the right to a fair trial. The Supreme Court of Canada had the opportunity to constrain the Crown's ability to do this and to say, hey, if you're going to charge someone with a criminal offense, especially like in this case, a firearms offense, something very serious in our justice system, you'd better have your act together when you lay those charges, or at least by the time that the matter goes to trial, so people know the case that they have to meet. In the circumstances, this is a situation where the Supreme Court of Canada could have put some limits on the Crown's wide latitude to amend informations in criminal proceedings, and unfortunately they failed to do so. This sets up a very dangerous precedent in our justice system that gives too much power, in my view, to the Crown in amending informations and prevents people from having trial fairness. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and please like, subscribe, and share with your friends.